Let me thank all my esteemed colleagues on the petitioners who brought in a lot of very insightful understanding of this emotion, passion-ridden issue and complicated from many aspects. And we tried to bring our own, if possible, keeping in mind the objectivity as well as the neutrality which is to be involved in understanding this. And some American historian said objectivity is not neutrality. For sometimes these things can become problematic. So keeping in mind, and I am also reminded of a very famous statement made by Abraham Lincoln in 1864 in response to a border territories conflict issue. He talked about balancing the nation, losing the nation, and preserving the constitution. And he said, by general law, life and limb must be protected. But yet often a limb must be amputated to save a life, but a life is never wisely given to save a limb. I'll place that very full extract of it later on. For balancing between losing the nation and preserving the constitution, which will be my running theme in trying to say, we want to say that constitution will be preserved in the context of the processes, due processes, the fairness of the processes, and how these procedures are important for the integrity of the constitution on the one hand, and losing the nation on the other hand.
Equally, Mr. Attorney General, we can't postulate a situation where the ends justify the means also, right?
I know about that, but
means have to also be consistent with the ends.
We all of us understand that. So very often this question confronts all of us, both in personal life, public life, the politics of the nation, the dynamics of the political process, and so on. But then that is a question which definitely confronts. So how do you find answers which will probably produce the most sensible solutions? So let me try to read this summary. No factual or legal foundation.
Yes.
Yeah. No factual or legal foundation for any sovereignty argument. On a combined reading of the instrument of accession and the proclamation, followed by adoption of Article 370, all trace of sovereignty, if any, were surrendered and disappeared. The constitutional integration process of the state of Jammu and Kashmir with the Union of India, howsoever sought to be brought about, was the only object of Article 370. All principles and procedures pressed into service for the above purpose will always be considered subservient to this purpose. The power and deliberation authority of the President under Article 370 to deal with it in any manner is neither lost nor removed by reason of its exercise over a period of time, nor it can be said that the provision erased itself without intervention by any positive lawmaking power. Article 370 was conceived and designed to aid the constitutional integration process on the same line as it happened with other states. Its continued exercise over a period cannot be seen as a cloud over or a distortion of its original purpose. Any discretion exercised beyond its original purpose, seen as introducing room for whittling the constitutional integration or otherwise, can always be deliberated upon to bring about any changes in its contents or its abrogation. All judicial pronouncements in regard to Article 370 must be seen in the context of the challenges and claims placed before the court and their total view to be kaleidoscopically seen. Border states are a special class of territories of India, and their reorganization in Article 3 will deserve distinct consideration. The court will defer to the wisdom of Parliament in the choices of action relating to border states. The justiciability of decisions taken to deal with matters relating to border states may not be, as in the case of general run of reorganization of states or imposition of President's rule. The scheme and architecture of Article 356, which provides in regard to the sustenance of the fabric of the nation, will not be narrowed or compressed. The interim argument demanding course correction or linearly tailored and need not be touchstone for ex ante tinkering in the undefinable state necessity potential of Part 18 of the Constitution. All instruments in aid of discharge of duty under Article 355, including the preamble to the Constitution, will be comprehended in the plenary power of Parliament to engage in the reorganization scheme under Article 3. The plenary power to act under Article 3 is available even during rule under Article 356. Long-standing or similar measures in regard to reorganization are not precluded. The availability of power is distinct from any due process. A. Neither asymmetrical federalism nor any other federal features have been infringed. We'll try to make good all these arguments. No rights in relation to representative democracy have been taken away. Reorganization of states includes temporary or other rearrangement of rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measure of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace and justice have no inherent justice right to continue to exist, to right to exist or to continue. However, it is submitted that all measures taken are within the due processes granted and to be pressed into service to act in exceptional circumstances. All steps taken under so-and-so are within the standard set of provision issued during President's rule, and nothing arbitrarily designed has been provided for. All arguments and fraud and power are therefore misconceived. That's a broad summary of my submission. Just before the solicitor takes over, as part of the paragraph 7B, the last few sentences, I looked into all the presidential proclamations, running into 120 of them, and particularly in regard to Jammu and Kashmir. The suspension of provisions of Article 3, the two provisos, and various other provisions in the Constitution of India, or in terms of a convention that the presidential proclamation follows. So no deviation has taken place as far as this particular presidential proclamation is concerned. So suggest therefore either a fraud on the Constitution is completely misconceived. I'll try to make good arguments referring to the documents. So I just want to play this summary to show that the due process has been followed. There is no deviation from due processes. All fall within the legitimate aims and objects of what the two orders sought to achieve, and the Reorganization Act also falls within them.
Thank you. Thank you very much.